Well, the contentious defense deal of Rafale aircraft has been stirring up the political scene of the nation for quite some time now, with the opposition led by the Congress and many experts, activists, journalists and lawyers questioning this deal. Congress accusing the government of discrepancies in this deal with France. The government, though, has stood firm on its ground and said that there has been nothing wrong that has occurred here. Now, with the Supreme Court verdict dismissing the pleas that sought an independent probe into this deal, is the matter done? To talk on that and on many other big developments in the nation today, we have with us former Union Minister, author, journalist, economist, and also a petitioner in the Rafale case, Arun Shourie, joining us. Good evening, Mr. Shourie. Thank you for speaking to Mirror Now. Mr. Shourie, let's begin with the latest development in the Rafale deal. The government has filed a fresh affidavit in the Supreme Court today, stating that perhaps the procedure has been misinterpreted and that it is up to the Supreme Court to issue further clarifying orders. What do you think of this development?
Yeah, what is this procedure which they are saying is misinterpreted? They have supplied false information to the Supreme Court. The Supreme Court could not have invented a PSC report. They could not have invented a CAG report. So these people supplied false information and now they are caught. But there is a bigger problem also. Why did the Supreme Court just swallow what the government had given it privately? This was not in the court. The Attorney General did not say it. I was there all the time. So this is the danger the Supreme Court has to guard against, taking things in a sealed cover, taking things in some way. The first duty which the Supreme Court owes to the country is to disclose the name of the person who gave them this false information, who misled the court in such a blatant manner. That is the first thing that they must do. This is not a private affair. And this is just one of the things. In matter after matter in this judgment, unfortunately, the Supreme Court has just taken the word of the government, repeated that word, and then said, actually, we should not be examining this. This is beyond our, this is not our job to look into the price. But they repeat the assertions of the government. Then, about the other aspect was about reducing after years of work, the Air Force, it was decided that 126 fighter planes of this kind are needed. And suddenly the Prime Minister cuts it to 36 planes. And the Supreme Court repeats the government's assertions on this matter, and then it says, in any case, it's not our job and we don't have the competence to assess the wisdom of buying only 36 planes instead of 126. Right. But you are repeating all those assertions. The same thing has happened in the case of offsets in choosing Anil Ambani's company. They repeat all the things that the government said, saying, for instance, that you didn't even have anything to do with this company. It is for Dassault to decide. We don't come into the picture at all. But the fact of the matter is, in clause after clause after clause of the offset guidelines and of the defense procurement policy, the chief vendor, in this case Dassault, has to, when he submits his technical proposal, he has to simultaneously submit what's called a commercial proposal, in which he must give the name of the offset partner. He must certify that the offset partner meets the very stringent requirements which have been laid down. He must list the experience and qualifications of that partner. This proposal is then to be vetted by a person called the Defense Acquisitions Manager. Then it has to be personally approved by the Defense Minister. And the government says, oh, we didn't know, who's this company? And the Supreme Court accepts all this. Just accepts means it just reproduces what the government has said.
So,
and it takes shelter, without saying so, Just 1 second, madam. You have asked an important question. It takes shelter, under an amendment by which the name need not be disclosed for a year. This amendment was made afterwards and given retrospective effect. That itself gave the game away that the government wants to pretend ignorance. Anybody could have seen through this. And this was pointed out to the Supreme Court. There is not a word about that retrospective amendment in the judgment. So what is this going on? We have faith in the Supreme Court. We went to the Supreme Court in this way, but it is certainly not the matter that you can just take in this case, the accused's word at face value, not even consider the facts which have been placed before you, reproduce the words of the government, and say, well, in any case, we should not be going into this matter.
Right.
It's very strange.
So, Mr.
And
Shourie,
I say this as a person who's fought for judicial independence for 40 years.
yes, Mr. Shourie,
Yes.
now that the government is saying that maybe you misinterpreted what we told you, and if it is about to do about something that was in that sealed cover that I don't know of and you don't know of and nobody knows except the government's legal officers
Madam,
and
just
the bench.
tell me something.
Yes.
Just tell me how well that 3 judges of the Supreme Court are going to misunderstand something which is written in plain English, that there is a CAG report. Just let me tell you what they say. Then let your viewers judge whether anybody there is any scope for misunderstanding or misinterpretation, as you said. So please don't go on just reading what the government says or this additional affidavit. He says, the material placed before us shows that the government has not disclosed pricing details other than the basic price of the aircraft even to the parliament. Okay? The pricing details have, however, been shared with the Comptroller and Auditor General, and the report of the CAG has been examined by the Public Accounts Committee. Only a redacted portion of the report has been placed before Parliament, was placed before the Parliament and is in public domain. There are 4 falsehoods in that 2-sentence paragraph. 4 falsehoods. Now, this is plain English. This is taken from some document given to them by the government. That must also be in plain English. So what is it that the government has now says that the 3 judges of the Supreme Court have misunderstood? And it is not only on this. I can show you 3-4 other matters in which the Supreme Court has just been either misled in this way or its own interpretation is odd. The next sentence, after this public domain business, it says, the chief of the air staff is stated to have communicated his reservation regarding the disclosure of the pricing details. Stated by whom? By the same fellows who have misled you on this, or whose plain English you cannot understand? And where is this letter? What is so confidential? If he objects to it, what is the problem of placing it in public? Why are you taking it in private? Or why is somebody giving it to you in private? And then, if you placed it in public, we would know, even, I tell you, even the date of that letter will speak a very big tale. Because supposing the date is after the sealed cover was given to the Supreme Court, that will then show something else, which is our information.
interesting.
So, there is no scope for interpretation in these matters. These are plain falsehoods given by the government, as it has been doing on every other aspect of Rafale.
Right. So
It has just been caught out. That's all.
Will you, Mr. Shourie, along with Prashant Bhushan and Yashwant Sinha, go back to the Supreme Court and ask them to reconsider and re-look at this case completely? Because if the court says that they don't see a case of favoritism, if the court doesn't see merit, but it turns out that the court either misinterpreted or was lied to, then do you think there is a case for effectively a retrial?
Well, in the retrial, they are not trying. They are considering a petition. And that's very different from a trial. Now, actually speaking, not one of the facts which we had placed before the Supreme Court has been dealt with at all in the judgment. Not one. In one instance, they reproduce the submissions of Prashant Bhushan, but they do not deal with it. That's all. In the matters of Anil Ambani, in the matter of pricing, in the matter of procedure, not one fact has been dealt with. Just what the government told them in plain or complicated English, which they could not, or which they have misinterpreted, they have reproduced that. But the problem about the review petition in these matters is that it goes to the same three judges. Now, if the judges are so big-hearted and so much like Gandhiji, who can own a mistake that, yes, this was a Himalayan blunder, it is one thing. But in this matter, I think I can speak for Mr. Yashwant Sinha also, that both of us will be guided by Prashant's assessment.
Sure.
He's a lawyer. He deals with these judges every day. We have dealt with them only in this particular case. But I have a slightly different view. The remedy does not lie in the going in a review petition. The remedy lies in you and me and everybody, and every one of your viewers reading such judgments. After all, this is just 29 pages or something.
Yes, 29 pages.
And so we should read this judgment. Don't go by X says this and Y says this. Read it and then analyze it and give your analysis, spread it as far wide as possible. And whether the court holds in your favor or not is a different matter. I'll give you a very good example. Gandhiji goes to Champaran. Indigo cultivators are in distress. He asks for a very small thing. Set up a committee. The district officers should set up a committee to examine the condition of the indigo cultivators. Now, if the district commissioner sets up the committee, then the mighty British Empire has bent to this half-naked fakir. If it does not bend, if it does not set up that committee, then Gandhiji's point is proven, that this government will not set up for even a committee for examining your condition, and you are thinking it is your my baap. So also in these matters, let us say we take the matters to the Supreme Court. The facts are clear. You must. It is contingent on the premise that you are speaking, that we are speaking the truth, and the facts are speaking for themselves. If after that also the Supreme Court does not deal with those facts at all, well, then you have done a great service. You have shown the condition of the institution to the country. So please remember, we are not on trial.
Absolutely.
The courts also are on trial.
Yes. No, of course, what I was asking you is if there is a possibility.
And I think this is such a, pardon?
No. So exactly my question was that if there is a possibility of you going in for review petition, but like you said, perhaps Mr. Bhushan will need to look into this now, legally speaking, and then take a call. I had another question for you, Mr. Shourie, and that's to do more with the policy-making jurisdiction of the government. In this case, for example, the Supreme Court did make it very clear in the beginning that they're only going to examine a certain part of the deal. They do not want to enter the territory of policy-making or decision-making of the government. You have been part of the policy-making arm. You've been part of the government yourself. Do you think when it comes to crucial deals and crucial policy decisions, there has to be a line drawn for interference either from the judiciary or elsewhere? Don't you agree on that?
No, that's a very good question. Now, but this is not a new thing which the Supreme Court has said. For about 50 years, this is the self-restraint which the Supreme Court has exercised, that we will not enter the policy domain. We will examine, but if what you have done is mala fide, if there are no reasons for it, if you can't justify it, a deal, it is a commercial deal. It's not a policy. Supposing you say, I have a policy towards China, that China is my adversary, I will position this or that there. That's a policy. And the court will rightly say, well, that's not my domain. But if you buy a piece of equipment and on that you can't explain how the price was tripled from 660 crores to 1660 crores, you can't explain that. That's not a policy. Is it your policy that prices will go up by 3 times? Is it your policy that after years and years of work, the Air Force will decide and all the competent committees will fix that you will take 126 aircraft, okay? Secondly, that 18 of these will be taken in a flyaway condition and the other 108 will be made in India. They will be made by HAL and the vendor who succeeds will have to transfer technology completely so that we become self-reliant in making these advanced fighter jets. That's policy. Now, here is a thing which after it has been done, you must know that under the guidelines, once this process has been completed, it is what is called set in stone. You can't change it. Now, suddenly the Prime Minister goes. 2 days before that, 2 days, the Foreign Secretary briefs the journalists about the Prime Minister's forthcoming visit. He's talking of this deal with these 3 components: 126 planes, transfer of technology, make in India by HAL. That Trappier, the CEO of Dassault, speaks in the presence of the Air Chief and in the presence of the HAL. He's so confident. We are 95% of the negotiations are complete. We are going ahead with this deal. And suddenly, that evening, the Prime Minister announces that no, we are taking only 36 aircraft at triple the price. That's how it turns out later. And the French President says, well, that was the new formula of the Indian government, and Anil Ambani was a part of the new formula of the government of India. These are his words. And we had no choice. This is policy, is it? So, when somebody repeats to you a phrase of policy and other things and so on, please examine what is a policy and what is a transaction. And that is the distinction which the courts have made.
Right. See, the other argument and the other allegation, Mr. Shourie, has been about Reliance being made the offset partner in this case and how they overnight allegedly set up this company, and that must be looked into if there was favoritism, if that was part of the deal that the government struck with France or not. But the fact of the matter is that Reliance and Dassault have been partners. And, since 2012, there have been talks about them working together. So is there enough evidence to suggest that there is malafide here or is some kind of a wrongdoing?
Now, you see, that's a very interesting point that you have made. You just now said, and that is what that actually shows how the Supreme Court has not examined the matter. It also says Reliance had been in discussion with Dassault since 2012. Which Reliance? Mukesh Ambani's Reliance, not Anil Ambani's. They were fighting, don't you remember?
Yes.
They were at loggerheads. It was Mukesh Ambani's cash-rich Reliance, which was deciding to enter the defense sector. And here is the cash-starved, debt-ridden group of companies of Anil Ambani. And like you, the Supreme Court conflates the two. It was Mukesh who was in touch with this, the Dassault CEO, Rapier. That matter is on record. Anil comes in only those 10 days before the deal.
Yes.
And just as your question conflated the two, unfortunately, the Supreme Court conflates the two and again shows that they have not exercised their mind as they are in duty bound to do.
Yes, absolutely. No, in fact, I was quoting from the Supreme Court verdict itself because I found that aspect also very intriguing, and I wanted to know from you what you thought of it as well, Mr. Shourie. So thank you for also clarifying on that aspect.
Correct. Yes. Absolutely correct. So that was a very good question.
Mr. Shourie, since we have you here,
the whole judgment.
Go ahead, please finish your point.
Yes, please. No, I was only saying, just to supplement what your very good question was, that actually speaking, though this is such a brief judgment, it is riddled with many such clues, if I may say so, that they have just taken at face value what they were told by one side only and tried to summarize it in this way, which now the government itself, their beneficiary, says has been a misinterpretation on the part of these judges. Next, it will be Mukesh Ambani who will be saying that it is a misinterpretation and that they have dragged in his name when it was Anil Ambani's name.
Yes. Yes, absolutely. Mr. Shourie, what do you have to say to those who now state that this is very convenient? Now you're questioning the same Supreme Court and the same Supreme Court bench and their verdict. But if it had gone in your favor, you would have welcomed it. You backed the same judges, the same CJI who a year ago was revolting and holding news briefings. You were welcoming his stand now, and now you're questioning what this bench has decided. What do you have to say to those people?
That you are idiots. That's what the word I would use for them, that you are just idiots. We are not, I have written 26 books, madam. Maybe 5 or 6 of them deal with the Supreme Court. They are sometimes praising certain judgments. They are sometimes very critical of certain judgments. It's not the court, it is a judgment. It's not that I am praising Mr. Gogoi and the 3 other judges as, as human beings. No. Or as fathers-in-law or sons-in-law or mothers-in-law. No. You are not judging a person. You are focusing on a particular judgment and on a particular act. For instance, when Justice Chilameshwar, Justice Gogoi, Justice Joseph, Justice Lokur addressed the press, they did not hold what you call press conferences. They held one press conference. I applauded them when people like Mr. Nariman, Mr. Soli Sorabji and others criticized them. They said, it is on that particular act. I felt that they were doing a service to the country by taking the country in confidence as to the state of the Supreme Court and how benches were being fixed by the then Chief Justice. I had myself written about it. I have a book on this. And had it not been for that disclosure, by now the Supreme Court would be in the condition of the RBI and the CBI. So they did a national service. They stopped an avalanche. Now, in the same case, some judgments of Mr. Gogoi must be very good. For instance, we have relied in our own petition on a judgment of a 5-judge bench of the Supreme Court called Lalita Kumari. Of the 5 judges, one of the judges was Mr. Gogoi.
Yes.
And our plan, one of our complaints today is that This very judgment disregards the principles laid down in Lalita Kumari by a 5-judge bench, including Mr. Gogoi. That's not a reflection on Mr. Gogoi, it's a reflection on 2 judgments.
Yes. Well, I take your point there, Mr. Shourie.
Idiocy which has become the
Yes, unfortunately, we've run out of time, Mr. Shourie, so I have to interrupt you there. But yes, I wish we could have continued this conversation, and I wanted your thoughts even on the CBI and RBI crisis, perhaps another day. Thank you so much for speaking to us and to the viewers of Mirror Now on this big story. Thank you, Mr. Shourie.
Thank you. Thank you.